Hello intellectuals, welcome to our channel. Now in this video, before going into the general principles of contract law, we will see how the contract law was developed by tracing the history of the same. Indian contract law is based on the English law. The English contract development history was mainly influenced by ancient Greek and Roman laws. During earlier period, the Roman law identified many categories of contractual transactions. Each of the contracts had its own requirements, which needed to be fulfilled for its enforcement. There were 4 categories of consensual agreements and 4 kinds of contracts, creating 2 property rights, namely pledge and secured loans. Roman law thus represented many specific kinds of contracts depending on their nature of transactions. During the medieval period, the number of English courts were minimal. Hence, there existed several number of methods for settling the disputes without going to the courts. In the local and the lowest courts, the first treatise by Ranulph de Glanville, that is, Treatise on the Laws and the Customs of English Kingdom, was applied in the year 1188. If people disputed in the payment of a debt, then both the parties to the debt, that is, creditor and debtor, and their witnesses would attend the court and have evidence by swearing oaths. Since the parties to the debt and their witnesses are giving false evidence, they avoided approaching courts, but rather were encouraged to resolve the disputes by alternate dispute resolution systems. The royal courts were fixed by the Magna Carta during the year 1215. These courts also settled the breach of contract claims where some breach of the king's peace had been alleged. A jury would be called to the royal courts to decide such claims. Gradually, these courts allowed claims where there had been no breach of king's peace. However, in such claims, there should be allegation of breach of king's peace. From the year 1350, the Court of Chancery and the King's Bench started to allow claims without the false allegation of force and arms. In the year 1381, the doctrine of consideration was formed to enforce any obligation. Consideration is something of many value. The courts awarded damages, that is compensation, only if there was a loss or a damage incurred by either party in a broken agreement. The Statute of Frauds in the year 1677 codified the contract types and it specified the required forms of contracts. In international coastal trading, the merchant customs played a most influential part, especially in the coastal trading ports like London, Boston, Hull, and King's Lynn. During 1500s, litigation sharply increased due to expanding trade activities and also been due to a centralization of lawsuits in the King's Bench and the common players. In the late 17th and 18th centuries, Sir John Holt and then Lord Mansfield actively developed the principles of international trade law and customs by incorporating the same in English common law. The principles of commercial certainty, good faith, fair dealing, and enforceability of seriously intended promises were some of the principles incorporated in the English common law. According to Lord Mansfield, mercantile law is not only whereby the law of a particular country, but the law of all nations, and also the law of merchants and the law of land is the same. Industrial revolution in England around 1760, the English courts became more and more joined to the concept of freedom of contract. It was considered a sign of progress as state restrictions on workers and businesses were removed. The transactions which were till then were of status, but from the year 1760 onwards it became status to contract. Everybody had the same degree of free will and a generalized law of contract was expounded. In the case of printing and the numerical registering company versus Samson, Sir George Jussel M.R. held that contracts when entered into freely and voluntarily are to be held sacred and enforced by courts of justice. The Judicature Act 1875 laid down the equitable principles such as estoppel, undue influences, rescission for misrepresentation, and fiduciary duties or disclosure requirements in contractual transactions. However, the essential principles of English contract law remain the same for the enforceability of contracts, that is, an offer for certain terms, an acceptance, consideration, free consent, that is, free from duress, undue influence, or misrepresentation, fairness in exchanges between unequal parties, general obligations of good faith, that is, liabilities not to be forced upon the people without their knowledge, etc. These rules were applied to all nations under the British Empire. India, being a colony of British Empire, enacted in the Indian Contract Act 1872, incorporating the above English principles of the contract. When the Sales of Goods Act 1893 in the British Parliament, India followed the suit by enacting the Indian Sales of Goods Act 1930. In the beginning of the 20th century, the legislative changes in the law of contract changed the attitude of courts, which effected wide-ranging reforms in the contract laws, which existed in the 19th century. The Misrepresentation Act 1967 shifted the burden of proof on persons making misleading statements. The Unfair Contract Terms Act 1977 created the jurisdiction to scrap contract terms which were unreasonable, curtailing the bargaining powers of one party. The principle of collective bargaining and growing number of employment rights developed the employment contracts, which in turn developed a new branch of law called labor law, where workers had rights like a minimum wage, fairness in dismissal, the right to join a union and take collective action, and these rights could not be taken away by a way of contract with the employer. Since the business and the commerce became widened, the scope of the general law of contract became limited, and hence special contract law had been enacted. Thus, the Partnership Act, the Sales of Goods Act, the Negotiable Instrument Act, the Transfer of Property Act, etc., were enacted to settle the disputes in these areas. However, the general contract law remained the foundation of specific contracts. Due to globalization, there were increase in markets, opportunity of international employments, commercial contracts, etc., which required special contract law to settle the disputes evolving from these areas. So, in addition to the existing contract laws, the international commercial arbitration laws were enacted. From this lecture, you all would have understand the evolution of contracts and the agreements in India reflects the country's historical, cultural and economic journey. From its ancient roots in religious texts to the amalgamation of indigenous practices with English common law during colonial rule, Indian contract law has continually adapted to meet the changing needs of its people. So, in my further lectures, we will see how the Indian contract has evolved, its general principles, and how the judiciary has interpreted the same. Do follow the Courtroom Intellectuals for further lectures.